Shares gives you ownership and control, but subject to the provisions of CAMA and the Article of Association. This is day 7 of the 30 days Know Your CAMA challenge by Beyond the Boardroom with CJ. And today we're looking at sections 149 to 174. But before we proceed, let's just use this opportunity to say Happy International Women's Day to all women out there. And thank you to those who continue to show us what is possible. We are going to we continue our discussion on shares. But before I proceed, I'll just love to say that when I was preparing for this particular recording, I told myself, there are some things that you can only explain, but for you to have an in-depth understanding of what we're talking about, there's so much control and power that your shares in any company gives to you, right? Even the way you are able to even, manage the affairs of your power in terms of your rights, your obligations in terms of shares. And when I was reading this, I was like, there's some things I cannot just read for you to, you wouldn't appreciate it like that. You would only appreciate it if you sit down, read it. If you don't understand it, then you can reach out for more questions, especially if you're preparing for exam and you're following this challenge or you're a student. I would really, really encourage you to pick up your CAMA and look through it. Today is going to be different because I noticed that if we go through our normal reading method, we may miss out on some points that would love for you to get in terms of understanding this concept of shares as outlined in sections 149 to 174 for our discourse today. But we'll just try. Let's start with allotment of shares, sections 149. So the power to allot shares is not necessarily exercised by the directors of a company unless such authority has been expressly vested on them by the company in a general meeting or the company's articles. The power to allot shares of a public company is subject to the provisions of the Investment and Securities Act, right? Then method of application and allotment. So for private companies, right, or for public company where the issue of shares is not public, such applicant shall actually apply in writing to the company stating his intention to buy the shares and number of shares that this person intends to subscribe to. Then, of course, in case of a public company where the shares are to be public, such application will be subject to the conditions imposed by the Securities and Exchange Commission. We move on to the next, which talks about the application. So where for private company, now I go back to private company, where but even though CAMA did not necessarily state the difference, it just said, it just sections 150, just method of application and allotment. So why I'm being very careful is because when you're dealing with private company and public company, you have to be very careful because what may apply in private company may not apply in public company, and what may apply in public company may not apply in private company. I hope you get what I'm talking about. But sections 150 sub C says that upon receipt of the application and the company accepts the application either in whole or in part and it wants to make an allotment, it shall within 42 days, right, make after the allotment, notify the applicant of the fact of allotment and the number of shares allotted to such applicants, right? We move on to the next, which is the payment of allotments, and sections 152 just says that subject to the provisions of 160 and 163 of this act, a company may in its articles make provisions with respect to payments on on allotment of its shares. We look at the effect of irregular allotments. So if, especially in a public company, because that's where it is being addressed, 153 says an allotment made by a public company before the holding of a statutory meeting to an applicant in contravention of the provisions of this act is voidable at the instance of the applicant. So it depends on the applicant to actually make it right, make an irregular allotment right. So the would I call it provisions now, or the provisions for making such irregular allotment voidable is outlined in sections 153. We move on to the next as return as to allotment in sections 154. So when allotment has been done, the return of allotment has to be filed with the commission within 15 days the CRP, I would have outlined all that should be attached to this filing: the return of allotments form, the number of and nominal value of the shares, the name and address of the allottees, and all of that. But on the company registration portal, right? Every company actually has its own page on the CRP. We move to the next, which is, of course, failure to. Once CAC gives a timeline for something, you should know by now, if you've been following us, that failure to comply actually attracts a penalty, and for this, it's a daily penalty. The next is prohibition of payments. So it just basically explains that you can't give somebody a commission or a discount, basically, for them to subscribe to the shares. However, there is an exception as to powers to pay commission in certain cases, and that's outlined in sections 156 of CAMA. We move on to the next, which is the call on and payments of shares. So where a subscriber has not fully paid up its shares, the directors, of course, subject to the terms of issue and the articles of association, the directors may make call on shares, and this call is deemed to have been made. We're talking about sections 158 here. Section 158 sub 2 says that a call is deemed to have been made at the time when the resolution of the directors authorizing the call was passed, and may be required to be paid by installments. The next is the payments for shares, right? Subject to the provisions of sections 161 and 62 of the shares of a company and any premium on them shall be paid up in cash, or where the articles so permit, by valuable consideration other than cash, or partly in cash and partly by a valuable consideration other than cash. Sections 162 talks about the payments for shares of public companies other than in cash. So in a public company, where a public company agrees to accept payments for its shares otherwise than wholly in cash, it shall appoint an independent valuer who would then determine the true value of the consideration other than cash, and prepare and submit to the company a report on the value of the consideration. It's very important for us to note the meaning of valuer in sections 162 sub 6. For the purposes of this section, valuer means an auditor, a valuer, surveyor, an engineer, or accountant, not being a person in the employment of the company, nor an agent or associate of the company or any of its directors or officers. So when you're choosing your valuer, this is your guide. We move on to the next, which is lien on shares. And for shares in this particular section, we're referring to shares that have not been fully paid for. So the part of the shares that have not been fully paid is what we're speaking to right now. So a company has a first and paramount lien on every share, called or payable for a fixed time in respect of that share, and the company also has a first and paramount lien on all shares other than fully paid shares standing registered in the name of a single person for all money presently payable by him or his estate to the company, but the directors may at any time declare any share to be wholly or in part exempt from the provisions of this subsection. Even though the company has a right to to retain and sell, such sale, sections 164 sub 3 talks about how such sale shall be done. Move on to the next, which is forfeiture of shares, sections 165. Remember when we talked about the call, right, on shares? So after such call, if a subscriber has not paid the amount due on such call or the installment thereof, such a person shall forfeit. They are liable to forfeit that aspect of the shares which has been unpaid for, and it just means that you forfeit it, you leave it, you let it go, it's no longer yours. So if sections 165 sub 4 says a forfeited share may be sold or otherwise disposed of on such terms and in such manner as the directors may think fit, and at any time before a sale or disposition, the forfeiture may be cancelled on such terms as the director may think fit. A person, subsection 5 says, a person whose shares has been forfeited ceases to be a member in respect of the forfeited share. We move on to the next, which is 166 and 167, talking about the part vary rights in different classes of shares. But like I said before, some things will not make sense to you, even if I took my time to read it one after the other. It would only make sense if you sit down, read it, and understand it, because sometimes the language just seems a bit, the next is rights of a preference share to more than one vote. Recall, I think it was on day 5 or day 6 when we discussed sections 140 that says that every share entitles you to one vote, however, subject to 168. So this is now the 168, and it is just talking about the right of a preference shareholder to more than one vote. It has outlined the circumstances where a preference shareholder is entitled to more than one vote, and it will be of good interest for you to read it yourself. Sections 168. We move to the next, which is construction of class rights, right? So as you're trying to construe the rights in different classes of shares, sections 169 provides what you should consider and what is presumed, right, except expressly stated. So we move to the last, which for today, which is the issuance of share certificates, right? Sections 171 says every company shall, within 2 months after the allotment of any of its shares and within 3 months after the date on which transfer of any such share is lodged with the company, complete and have ready for delivery the certificates of all shares allotted or transferred, unless the conditions of the issue of shares otherwise provide. You just ask her, what is the effect of this? See, it's really important for you to obtain your share certificates, because you'd ask what is the effect, and I'm going to tell you, a certificate is prima facie evidence of the title of the members of shares. So if you don't have your evidence of membership, how would you prove your membership? So I think this is a call for you today to speak to your company secretary or speak to that company that you own shares in to give you your share certificate if you haven't seen it or if you don't have it, because it's very important aspects of the ownership and control that you have in the company, right? I think that's all we can take today on day 7, and I'll see you on day 8.